I'm Darryl York. I'm a 24-year retired police veteran. I'm now a criminal defense attorney. If you get arrested for DUI marijuana in California, the first thing you need to do is hire an attorney. I would not plea out to that case whatsoever. You need to fight that all the way, especially if it's marijuana only. You walk into court and they show you a lab receipt showing there's marijuana in your system. That doesn't mean anything. You have a good chance to fight this case and win this case in trial or get a dismissal. So just because you get the handcuffs put on you and dragged in, you need to put up a vigorous fight. DUI marijuana is a difficult case for the prosecution to prove up. It's difficult because they have to show impairment. It's not a per se statute like alcohol. With alcohol, they can establish your guilt by proving your blood alcohol level was at 0.08 or greater within 3 hours of driving. Marijuana, they have to prove that the marijuana impaired your ability to operate a motor vehicle to an appreciable degree. It's difficult. It's difficult because studies have shown that marijuana, at first when you ingest it, actually, you're more focused in your driving. There's been all sorts of studies. So if you're more focused, how is it impairing your ability to safely operate a motor vehicle? If you're convicted of DUI marijuana in California, the penalties can vary. If you're pleading out to the impairment count, it's probably going to be the standard, just like an alcohol-related offense. It's going to be 3 years probation, $390 fine, plus penalty assessments. They may require you to do the 3-month alcohol class, which is kind of redundant in my opinion, because there's no alcohol involved. But those are the penalties. And while you're on probation, you're not to operate a motor vehicle without a license and properly insured. No drugs in your system, submit to any chemical test by a peace officer. If you plead to the impairment count. If they reduce it to like a wet, reckless, or a dry, it can vary. It could be maybe 1 year probation up to 3 years probation. There may be DUI conditions, or may not be DUI conditions. It really depends on what charge you pled to other than the impairment count. DUI marijuana cases that I've handled in the past, I rarely allow my client to plead to that charge. I usually get them dismissed or get them to plead to a lesser charge. I had one case in Ventura County where it was DUI marijuana. I had an expert review the file. He was a drug recognition expert. We had a quantitative analysis done. There was no delta-9 THC in the system. My expert was better than their expert, and he wrote me up a memo, basically, which I submitted to the district attorney, and they decided to dismiss the charge.